Mute of malice or mute by visitation of God. Two of my favourite legal phrases, because they sound like something Vincent Price would say in a 1970s Hammer House of Horror movie. However, even though they do date back to before 1215, they're still good law. So what's brought all this on? It's actually, you know that Southport, that horrible Southport case, where the kid basically turned up in court and just refused to speak. So what's actually going to happen there? Well, I'll look at what's likely to happen, but also why we still have this old archaic law on the books. But before I do that, I would just like to say thank you to everybody for all your kind comments about the Ramsey Hunt thing. I'm taking, basically, they gave me a big bag of pills. It's like early 90s Essex around my house at the moment. But the good news is the doctor said you can only get this once. Although I did say, well, that could either be a really good thing or a really bad thing. But apparently it's a really good thing. But anyway, enough rambling. But like I say, I do appreciate all your kind comments. Okay, so people turn up in court and they just refuse to speak. They refuse to cooperate. They refuse to say anything. What actually happens? Well, to cut to the chase, under the modern criminal procedure rules, the usual procedure is that they just enter a not guilty plea on the defendant's behalf and carry on with the trial. But it does bring in sorts of issues as to, well, are they just non-cooperative? Or is there something wrong with them? And, you know, you get into issues about fitness to stand trial. But what used to happen back in olden days, and I do mean olden days, like I say, this goes back to before 1215. Well, it used to be that when you were put on trial for a felony, because prior to 1968 we still had felonies and misdemeanours, you'd be asked how you wanted to deal with it. How do you wish to be tried? And you could say, by God and my country, which meant I would like to elect a jury trial, because the alternative was you could have trial by ordeal. But what if you refused to enter a plea or to say that? Well, the procedure was that it was ordeal. So they would press you under stones and you would be basically put on the ground. I think Margaret Clitheroe, because I went to a school that involved Margaret Clitheroe, and I think she was crushed under a door. They piled loads of rocks on top of her. But they would leave you there until you were either crushed, you starved to death, or you suddenly decided you wanted to enter a plea. But why would people go through that? Well, the interesting thing is, if you were convicted after a trial, all your property was forfeited, so your family lost it all. However, if you were just crushed to death or starved to death, okay, it's not very good for you, but they couldn't confiscate your property. So a lot of people did actually choose that option just to protect their families. But people then said, well, hang on, we need to establish, are they being deliberately uncooperative, or is this something that's not their fault? And this is where the mute of malice and mute by visitation of God thing comes in. Mute of malice just meant you deliberately weren't cooperating. But mute by visitation of God, they recognised that some people, you know, there were things wrong with them, they couldn't communicate. And back in the days, this included things like just being, you know, a deaf mute, to use what is now considered to be rather offensive language. So who decided this? Well, actually, a jury was impanelled just to decide this specific point. But here's the thing, this procedure is still on the books, and there's been at least 20 cases in sort of recent years where this has actually happened. So they will impanel a jury, and the jury have to decide whether somebody is being deliberately uncooperative, in other words, mute of malice, or there's something wrong with them, which means that, you know, they're just not able to cooperate, you know, through some outside action. The case law is quite confusing. You know, what's the standard? I mean, it's been suggested that it's on the prosecution to prove to the requisite standard, and this was in the days when they used beyond reasonable doubt, that the person was mute of malice. Or was it just that the jury just had to find on the balance of probabilities? But what would happen if, you know, if they found somebody was mute by visitation of God? Well, in that particular case, they would say, okay, you know, they're not incapable of standing trial. I mean, it's basically the equivalent of like fitness to plead now. So they would have to take some other procedure. I mean, now when we find somebody's not fit to stand trial, what we'll sometimes do is we'll have a hearing to determine whether they actually committed the act. Because obviously, you know, if you're going to haul them off for a hospital order or something like that, that's still a deprivation of liberty. So you can't just say, well, you know, we accept that you're not morally culpable, however, we're still going to lock you up for life in a secure hospital. You will have a trial just to determine whether they committed the act. And then if they did, the judge has a lot of options. You know, they can do a hospital order. That's, you know, like I say, where you're just sent off, you know, to a secure hospital or whatever for treatment. They can do combined orders now where, you know, they say, well, actually, we accept for now you need a hospital order, but when you're well enough, you can start doing a prison sentence. But that's perhaps a topic that's, you know, for another day, because I just want to talk about this rather obscure procedure. What if, however, they decided you were mute of malice? Well, it used to be that you just basically, that was deemed to be, well, you just put in a guilty plea then. If you're not going to say one way or the other, we'll just assume you're guilty. That did change in the early 1800s. And, you know, like I say, it became complicated because they recognised, I mean, there's a case where it was just a woman who was deaf. So technically she was mute. And they accepted she's mute by visitation of God, it's not her fault. But they said, actually, no, she can communicate by sign language. Therefore, she's not actually, you know, silent doesn't necessarily mean silent. So in that particular case, they just had a trial for her. But like I say, the weird thing is, this still happens. Now, the other interesting thing is it the same jury that deals with that then deals with your trial? No, it isn't. It has to be a separate jury. There were some technical issues about it, like, I mean, it makes no difference now, because now we no longer have preemptory challenges to jurors. But it used to be that each side had a certain number of, we just don't want you on the jury. We don't have to give a reason, we just don't want you on the jury. That's all gone now. It's like effectively first 12 people out of the hat, unless they have some, you know, other, that you can challenge for cause, like actually that juror knows one of the witnesses, or that juror is somehow involved. I mean, it used to be, of course, that, you know, you could have police officers or lawyers on juries. That's all changed now. So really there aren't any challenges to jurors. But it used to be that you couldn't challenge the jury doing the mute of malice, mute by visitation of God, but you could then impanel a separate jury. But, I mean, like I said, now we just have effectively fitness to plead. If somebody just goes, you know, all stump on something, I mean, we're getting to this rather weird thing about the interface of mental health and, you know, criminal justice, because as lawyers, we're not, you know, mental health experts or anything. I mean, obviously we have some experience with people, and we can flag up to a judge and say, look, we think our client, you know, has issues. And then there might be an order for a psychiatric report or something like that to determine fitness to plead. This is separate, completely separate from, you know, things like insanity or diminished responsibility. That's about whether somebody was actually responsible for the offence in the first place. This is whether they were responsible or not at the time, are they now in a position where they can understand what's going on and properly give instructions? And if somebody's not speaking to you, you're fairly stuffed. I mean, the Bar Standard Board does have some rules about this. You know, you've got to do the best to protect your client's interests. But in the absence of instructions, what can you really do? I mean, obviously you can put the prosecution to proof. It's a bit like, you know, the old, what do you do if you know your client's guilty, if they've confessed to you? Well, you can still represent them. You can't put forward a positive defence. You can't say, I suggest to you, you were mistaken, that wasn't my client you saw, for instance, in an eyewitness case. But you can say things like, were you wearing your glasses? The lighting wasn't very good, you were quite a long way away, it was raining, something drove in front of you, it was just a fleeting glimpse. You can suggest that the identification is unreliable, but what you can't do is actively suggest it's wrong. And you get into similar issues where you're dealing with somebody who is, you know, just not able to cooperate with you. You can theoretically test the evidence, but in the absence of instructions, can you put forward a case and say it wasn't them? Well, you don't know because they've not said it to you. So, you know, this is all the thing that crops up now. But like I said, they still sometimes use this procedure. And, you know, effectively, if they find somebody is mute of malice, you know, they just stick in a not guilty plea and have the trial. If they find somebody is mute by visitation of God, then they more or less go into the fitness to proceed procedure. Now, obviously people have suggested this is all archaic and we don't need it now with the new rules. We can just, you know, deal with it under the modern rules. But the fact is, this has never been abolished. You know, it's almost sort of like slipped through, because it's almost like one of those old archaic things that people have sort of forgotten about. But it's never been formally abolished. And like I said, there's some interesting research where they found that in, you know, recent years, this procedure has actually been employed at least 20 times. So what will happen to this kid if he doesn't cooperate? Like I said, they'll just bang in a not guilty plea on his behalf, and they'll go ahead with the trial. If he doesn't cooperate with his lawyers, they can say, well, we're now professionally embarrassed. In other words, you know, we have no instructions. You have to make that decision about what's in the best interest of your clients. But if they find, you know, they can't take any instructions and they're not in a position to put forward a defence, basically he'll be on his own. The prosecution will present the case. There'll be the usual safeguards. I mean, the judge will obviously look after their interests. I mean, that's something that's also interesting about in the olden days. Rather weirdly, you could have representation if you were up for a misdemeanour, but you weren't allowed to have representation, a lawyer, if you're up for a felony. But the court actually came in and the court acted, you know, effectively as your advocate. It was the court's role and the judge's role to make sure that the conviction was safe, and that, you know, your defence was put forward, whereas now, you know, the judge is more the referee because it's an adversarial system. But in the old days, it was almost like an inquisitorial system where the judge was actually in charge. But yeah, like I said, I just thought you might find that sort of vaguely interesting, vaguely informative, and as always, vaguely accurate. So yeah, there you go. And like I say, once again, sorry, I'm just stood in a little country lane that's a lot noisier than I thought it was. I actually came out in this lane last night to watch some fireworks down in the local village, which I don't really approve of because, you know, they scare all the animals and stuff like that. But then I fell in a ditch, which I'm blaming on the Ramsay Hunt syndrome rather than just my usual incompetence.